Hello, my name is Mark Cooper. I'm a financial services disputes and investigations partner here in London. I'm joined today by my colleagues Matthew Howse, who's a disputes partner in our Belfast office, and Alastair Frood, who's a disputes partner in our Edinburgh office. We're going to be talking about freezing orders, or arrestment orders as they're known in Scotland, in our respective jurisdictions. This podcast arises out of publication in June of our Global Freezing Orders Guide, which provides an overview of freezing orders and their local law equivalents in more than 90 jurisdictions worldwide. Given the limited time available today, we are each going to provide a high-level overview of the key aspects of our respective freezing order or arrestment order regimes from the perspective of a third-party financial institution. So, starting with England and Wales. In England and Wales, the claimant will notify the freezing order to a financial institution which may hold assets of the respondent before service of the order on the respondent itself. This is to try and ensure an unscrupulous respondent does not have an opportunity to try to evade the freezing order by dissipating their assets before the financial institution has had a chance to freeze them. Notification will typically be in writing, but in urgent circumstances may be by phone. The important point here is that in England and Wales, there is no requirement for formal service of the freezing order, as there would be with, say, a claim form. However you're notified, you're entitled to a copy of the freezing order and any materials read by the judge who made it, as well as a note of the hearing. All of these should be requested if they're not otherwise provided, as they'll assist you with effecting the order, in particular dealing with the exceptions, which I shall come on to. There have been an increasing number of instances of fraud in this jurisdiction, and on receipt of a freezing order, we would therefore always advise that you carry out some straightforward checks to confirm the bona fides of the order. For example, that the freezing order is sealed, that is to say it bears the stamp of the court. It is in standard form. It is from an SRA, or Solicitors Regulatory Authority regulated firm, and the solicitor is on the roll of solicitors. And where the order is received by post, it is on the letterhead of that firm, and where it is received by email, the email address exactly matches the one for that individual on the firm's website, or where the individual is not on the website, the form of that firm's email addresses. If there is any doubt, you should confirm the bona fides by way of a callback to the relevant solicitor using the telephone on their website, not the one on the freezing order itself. So moving on to the prohibitions. An England and Wales freezing order prohibits the respondent from dealing with the assets identified in the order until a specified time, either on a domestic or a worldwide basis. It will also contain certain exceptions to that prohibition, and this is where things can start to get a little bit complicated. These exceptions include assets above a specified value, transactions in the ordinary and proper course of business, expenditure on ordinary living expenses, and either reasonable expenditure or expenditure up to a specified amount on legal advice and representation. Now, starting with the easiest of the four, assets above a specified value, in calculating whether a transaction is above or below this threshold, an institution will typically only take into account assets held with it, since it will not usually have sufficient visibility or assurance as regards assets held by other institutions, and will not want to be relying on representations from a respondent, particularly in circumstances where there has been found to be a risk of dissipation. Order in proper course of business means transactions which fall within the usual legitimate business of a company. That is a subjective assessment, but, for example, might include the payment of payroll, suppliers, or utility providers. What it is unlikely to include is transactions which involve the transfer of all or nearly all of a company's assets or the company's dissolution. The ordinary living expenses exception is similarly subjective, being the ordinary living expenses of that individual. Therefore, While, for example, the maintenance of a luxury yacht would not be an ordinary living expense for me, it may be for an oligarch. Similar issues of subjectivity arise in relation to legal expenses. In addition, this exception only relates to legal expenses for the purposes of the proceedings in which the freezing order was granted or ancillary proceedings. Critically, it does not provide a means of accessing legal advice or conducting litigation generally. However, such expenses may well fall within the ordinary and proper course of business exception. It goes without saying that these subjective assessments are fraught with difficulty, particularly because you, as a third party, are unlikely to have all of the background information, and you'll be wanting to put your institution in a position where it is taking the least risk. One practical way of dealing with the exceptions is to seek confirmation from the respondent's solicitors that they consider that a particular transaction falls within the exception, and make it clear you are not in a position to make that assessment yourself and will be relying on their representation to the extent you effect that transaction. That is a reasonable position to take given the professional obligations solicitors are under, which include acting with honesty and integrity and in a manner that upholds the constitutional principle of the rule of law and the proper administration of justice, and because they are officers of the court. The standard form England and Wales freezing order also contains some express protections for third parties, which I'll quickly run through now. First, a third party is not prevented from exercising any rights of set-off arising prior to its notification of the freezing order. Second, a third party does not need to inquire as to the application of any monies withdrawn by the respondents if the withdrawal appears to be permitted by the freezing order. Now, the important point here is that protection, although often suggested by solicitors for the respondent, does not get round the need for you to have correctly determined in the first instance whether the request does not fall within the terms of one of the exceptions. Third, a freezing order only affects third parties outside of the jurisdiction in certain circumstances. The chief one of these is where the third party is subject to the jurisdiction of the courts in England and Wales, for example, because they're a party to the underlying proceedings or because they have voluntarily submitted to jurisdiction. In this regard, it's important to remember that a branch of an entity which is in the jurisdiction is also in the jurisdiction itself, because it is not a separate legal entity. Fourth, as regards assets outside of the jurisdiction, a freezing order would not prevent the financial institution from complying with, firstly, what it reasonably believes to be its obligations under the law of the country where the assets are located, or the law of any contract between itself and the respondent, or any orders of the courts of the country where the assets are located. Fifthly, in obtaining the freezing order, the claimant will have had to have undertaken to pay the reasonable costs of any third party which have been incurred as a result of the freezing order, and to compensate them for that loss. And sixthly, and finally, in the event of a breach of a freezing order, the starting point is that a third party does not owe a duty of care to the claimant. It is therefore critical not to do or say anything that erodes that position. This can, and most commonly does occur, where a financial institution goes beyond simply acknowledging receipt of a freezing order, which it's not required to do in any event, and in fact goes as far as to confirm that they will effect the order or freeze the relevant assets, or words to that effect. At that point, I'll now hand over to my colleague Matthew, who will talk through the position in Northern Ireland.
Thank you very much, Mark. As Mark has said, I look after the dispute resolution and litigation team in the Belfast office of Evershed Sutherland. We handle a range of disputes for a wide range of clients, including, of course, financial institutions. One brief word on the constitutional position, I suppose, as it pertains to Northern Ireland. We are part of the United Kingdom, of course, but we are indeed a separate legal jurisdiction. So it's always worth, I think, just bearing that in mind. Having said that, the law and indeed, procedure and practice when it comes to freezing injunctions is quite similar actually to that in England and Wales. So I may take a slightly quicker canter through, given Mark has set out some of the fairly well-established principles that do apply for us here in Northern Ireland as well. A few very brief high-level points. Freezing orders are indeed available here in Northern Ireland in civil legal proceedings. The defendant will be prohibited from dealing with the assets that are referred to in that freezing order until a certain specified time. The relevant legal test is again much the same as it would be over in England and Wales, namely that the plaintiff, to use a bit of Northern Irish jargon rather than applicant, namely that the plaintiff has a good arguable case in the underlying substantive prospective claim or actual claim. The respondent has assets which may be within, in the case of a worldwide freezing order, outside of Northern Ireland. The court does generally exercise greater caution when granting relief in relation to assets overseas, unless there is a very strong connection to Northern Ireland. And of course, there has to be a real risk of unjustified dissipation of those assets. And of course, finally, always with injunctions that it's just and convenient to grant the freezing order. In terms of the process, just very briefly, again, quite similar to that in England and Wales, the applicant will make, or the plaintiff will make, an application to the court on what we call an originating summons, supported by an affidavit setting out the usual things that one would expect. So the reasons for the application, the basis on which the relevant tests are met. Usually these applications are without pleadings. There'll be no discovery obligation or disclosure, to use the England and Wales jargon, without a prior order of the court. And then, of course, we also have on notice or without notice applications as well. And if an application is made without notice, then there's a much higher duty of candour for the applicant, and there will, of course, be a return date fixed. So in terms of third parties, thinking of financial institutions, of course, can such an order be sought here in Northern Ireland against a third party? Well, yes, it can, much the same as in England and Wales. So we often would see a financial institution which may hold certain of the defendant's assets, and the financial institution would need to be notified to make sure that it doesn't effectively knowingly assist the defendant in breaching the order that is being made or has been made. In terms of substantive proceedings abroad and whether a freezing order can be made in support of those, well, yes, it can. At what stage here in Northern Ireland can such an order be sought? Really at any stage, including prior to the commencement of the proceedings in question. The exceptions to the general prohibition on the respondent's use of their assets that are subject to a freezing order, again, much the same as those outlined by Mark. What happens after the freezing order has been granted? Well, the plaintiff will typically notify third parties such as banks, financial institutions, of the fact of the freezing order, and assuming it has been obtained without notice, as is often the case, then as I already mentioned, there will be a return date for a hearing. In terms of any other particularly pertinent points for financial institutions, I suppose consequences of breaches of freezing or other equivalent orders. Obviously, a defendant who disobeys one may well be held in contempt of court, but also third parties. And of course, we're talking really here today about banks in particular. A third party really will probably only be in contempt of court where they knowingly help or permit the defendant to breach the terms of the order. And the mind goes back to the comments Mark made about just being very careful on the part of financial institutions about how they actually respond when they are provided with a copy of the order, or indeed notified of the order. There are a few other brief points I might just make in relation to whether or not third parties notified but not a party to the freezing orders owe a duty of care to the applicant. Mark touched on this, but in very short form, no, although one has to be careful, as Mark has outlined. And finally, can freezing orders obtained from overseas jurisdictions be enforced here in Northern Ireland? And again, the answer in general is probably no, apart from perhaps ones made in the EU and certain EFTA proceedings prior to 31 December 2020. So I think the summary from me vis-a-vis the Northern Irish position is we are quite similar really to the England and Wales position, as I've said. There are of course some local procedural nuances, procedural differences, but the underlying position is quite similar. And if anyone is ever in the unfortunate position of being notified of such an order, then do please liaise and get in touch. At that point, I will hand over to Alastair for the Scottish position.
Thank you, Matthew. My name is Alastair Frood. I am a head of litigation for Eversheds in Scotland, and we do a full range of general commercial litigation, including a lot of work for financial institutions. So I am well placed to provide some information about arrestment orders in Scotland. Today I am talking about arrestment orders, which are the equivalent in Scotland of the English and Irish freezing orders. An arrestment order is granted either on the dependence of a court action or at the conclusion of a court action in Scotland. The arrestment on the dependence is an application made to the court at the point you lodge your summons for warranting. You are required to attend in front of a judge, ex parte, and make representations which would persuade the judge to allow you the powers to arrest funds in the hands of a third party prior to commencement of the action. In order to be successful with the application, you have to persuade the judge that there is a risk of the defender hiding his assets or becoming insolvent during the process. The application will be granted, or if the application is granted, the judge will then sign the warrant and you are immediately permitted to then send it to a sheriff officer who will serve the warrant in person at a place of business of the bank, or if indeed a third party holds different assets such as a garage which may hold a motor vehicle that is owned by the defender, similarly that can be arrested in security for the action. On service of the arrestment on the dependence, the bank then freezes the account at that point in time. However, any funds which are received into the account after the date of the arrestment can be treated in the normal course of business, and the customer is entitled to remove them from the account as if nothing had been served. The arrestment then stays in place until either the conclusion of the court action or the defender makes an application to court to have the arrestment recalled on the basis that it wasn't necessary in the circumstances. From the bank's perspective, they have 21 days to notify the pursuer of any sums which have been caught. There's no requirement to notify if there's nothing being caught by the arrestment. The notification goes to the pursuer or the pursuer's agents. With regards to an arrestment on the conclusion of the action, that is granted without any application required to the court. It is part of the final decree and it is the normal course of diligence in recovering sums paid after a court action. Again, the arrestment is served by sheriff officers. It would similarly freeze any funds at the point of service, and again the bank has a requirement to notify the pursuer if any sums are caught. Unlike the arrestment on the dependence, however, if sums are caught within 14 days, there is a requirement to then pay those sums out to the pursuer in part satisfaction or whole satisfaction of the court action. It's worth noting that the sums which are arrested have to be reasonable. You cannot arrest £1 million against a debt of 5,000. The sums arrested would be agreed with the pursuer and restricted so that there's no question of unfair arrestment. That said, the full sum would be frozen at the point of arrestment, and it would be for the pursuer's agents to notify the bank to restrict the sum which has been caught. Thank you for listening to me, and if there's any other issues which you wish to discuss, then please feel free to get in touch with myself or any of my colleagues in the Edinburgh office. Thank you.
Thank you, Alastair. Well, that just leaves me to thank my co-presenters, Alastair Frood and Matthew Howse, to encourage you to look out for our podcasts on the other jurisdictions, the USA, Netherlands, Germany, Spain, the Middle East and Hong Kong. And finally, to say that if you ever have any questions on freezing orders, arrestment orders, or indeed any other court orders, please do get in touch with us.